The directors shall cause to be kept proper books of account with respect to all sums of money received and expended by the company and the matters in respect of which the receipts and expenditure take place. All sales and purchases of goods by the company. The assets and liabilities of the company. Cost accounts, where applicable. The books of account shall be kept at the registered office of the company or at such other place as the directors shall think fit and shall be open to inspection by the directors during business hours. The directors shall from time to time determine whether and to what extent and at what times and places and under what conditions or regulations the accounts and books of the company or any of them shall be open to the inspection of members not being directors, and no member, not being a director, shall have any right of inspecting any account or book or document of the company except as conferred by law or authorized by the directors or by the company in general meeting. The directors shall, as required by Sections 183 and 184 of the Companies Act 1994, cause to be prepared and to be laid before the company in general meeting such profit and loss accounts, income and expenditure accounts, balance sheets, and reports as are referred to in those sections. The profit and loss account shall, in addition to the matters referred to in subsection 2 of Section 185 of the Companies Act 1994, show, arranged under the most convenient heads, the amount of gross income, diminished in the case of a banking company by the amount of any provision made to the satisfaction of the auditors for bad and doubtful debts, distinguishing the several sources from which it has been derived, and the amount of gross expenditure, distinguishing the expenses of the establishment, salaries, and other like matters. Every item expenditure fairly chargeable against the year's income shall be brought into account so that a just balance of profit and loss may be laid before the meeting and, in cases where any item of expenditure which may in fairness be distributed over several years has been incurred in any one year, the whole amount of such item shall be stated, with the addition of the reasons why only a portion of such expenditure is charged against the income of the year. A balance sheet shall be made out in every year and laid before the company in general meeting made up to a date not more than 6 months before such meeting. The balance sheet shall be accompanied by a report of the directors as to the company's affairs, and the amount which they recommend to be paid by way of dividend, and the amount, if any, which they propose to carry to a reserve fund. A copy of the balance sheet and report shall, 14 days previously to the meeting, be sent to the persons entitled to receive notice of general meetings in the manner in which notices are to be given hereunder. The directors shall in all respects comply with the provision of Sections 181 to 191 of the Companies Act 1994, or any statutory modification thereof for the time being in force. Audit. Auditors shall be appointed and their duties regulated in accordance with Sections 212 and 213 of the Companies Act 1994 or any statutory modification thereof for the time being in force. Directors. Meaning and number of directors. Directors are persons elected by the shareholders from among themselves for the purpose of managing the business of the company. In a public company, there is a separation of ownership from control. To protect the interest of the company and of the shareholders, there must be directors. Section 91 states that every public company and a private company which is a subsidiary of a public company shall have at least 3 directors. Every private company other than a private company mentioned in subsection 1 shall have at least 2 directors. Appointment of directors. There are certain mandatory provisions which must be observed while appointing directors in the case of public limited companies. For private companies, it is usual that the articles provide the mode of appointment of the directors. But they have to look for the provisions applicable both for the public as well as private companies. The provisions for appointment of directors in public limited companies are: every company shall have at least 3 directors, Sector 91. Only natural persons can be appointed directors, Sector 93. The directors shall be appointed by the members in general meeting, 91(1), copyright. Causal vacancy may, however, be filled up by the directors. 91(1) Copyright. The duration of office of a director shall be liable to determination at any time by retirement in rotation. 91(2). A consent in writing by persons to act as directors must be filed with the registrar. 92(1)(a). A consent of directors to take qualification shares must be filed with the registrar or sign the memorandum of association by taking qualification shares. 92(1)(b). A signed consent to act as director should accompany the proposal for directorship to the company. 93. A director away from Bangladesh for a consecutive period of at least 3 months may appoint his alternate director if so authorized by the article or by a resolution of the General Meeting. Sector 101. Restrictions on appointment. Section 92 of the Companies Act lays down that a person shall not be capable of being appointed director of a company by the articles and shall not be named as a director or proposed director of a company, or in relation to any intent company in any prospectus issued by the company or in any statement in lieu of prospectus filed by or on behalf of a company unless before the registration of the articles or the publication of the prospectus, or the filing of the statement in lieu of prospectus, as the case may be, he has by himself or by his agent authorized in writing, signed and filed with the registrar to consent in writing to act as such director, and in the case of companies having a share capital either signed the memorandum for a number of shares not less than his qualification shares, or taken from the company and paid or agreed to pay for his qualification shares, or signed and filed with the registrar a contract in writing to take from the company and pay for his qualification shares, or made and filed with the registrar an affidavit to the effect that a number of shares not less than his qualifications shares are registered in his name. On the application for registration of the memorandum and articles, if any, of a company, the applicant shall file with the registrar a list of the persons who have consented to be directors of the company, and, if this list contains the name of any person who has not so consented, the applicant shall be liable to a fine not exceeding 2,000 taka. The above provisions shall not apply to the appointment of the chief executive, by whatever name called, of any insurance company or a banking company as a director of that company if the articles thereof provides for such appointment. Qualification shares. The articles of a company usually fix a minimum number of shares which every director must subscribe in order to become a director. This minimum number is known as the qualification shares. It is the duty of every director who is required by the articles to hold a specified share qualification and who has not already qualified himself accordingly, to obtain his qualification within 2 months after his appointment or such shorter time as may be fixed by the articles. SEC 97(1). If, after the expiration of the period mentioned in subsection 1, any such unqualified person acts as a director of the company, he shall be liable to a fine not exceeding 200 taka for every day between the expiration of the said period and the last day on which it is proved that he acted as a director, both days inclusive. Sector 97(2). Disqualifications of directors. According to Section 94, a person shall not be capable of being appointed as director of a company if he has been found to be of unsound mind by a competent court and the finding is in force, or he is an undercharged insolvent, or he has applied to be adjudicated as an insolvent and his application is pending, or he has not paid any call in respect of shares of the company held by him, whether alone or jointly with others, and 6 months have elapsed from the last day fixed for the payment of the call, or he is a minor. A company may in its articles provide additional grounds for disqualification of a director. Vacation of office of director. Under Section 108 of the Companies Act, the office of a director shall become vacant under the following circumstances. If he fails to obtain within the due time or at any time thereafter ceases to hold the qualifications shares, if any, necessary for his appointment, or if he is found to be of unsound mind by a competent court, or if he is adjudged an insolvent, or if he fails to pay calls made on him in respect of shares held by him within 6 months from the date of such calls being made, or if he or any firm of which he is a partner or any private company of which he is a director, without the sanction of the company in general meeting accepts or holds any office of profit under the company other than that of a managing director or manager or a legal or technical advisor or a banker, or if he absents himself from 3 consecutive meetings of the directors or from all meetings of the directors for a continuous period of 3 months, whichever is the longer, without leave of absence from the board of directors, or if he or any firm of which he is a partner or any private company of which he is a director accepts a loan or guarantee from the company in contravention of Section 103, or if he acts in contravention of Section 105. Loan of director. Section 103(1) states that no company, other than a lending company mentioned below, shall make any loan or give any guarantee or provide any security in connection with a loan made by a third party to any director of the leading company, any firm in which any director of the lending company is a partner, any private company of which any director of the lending company is a director or member, any public company, the managing agent, manager or director whereof is accustomed to act in accordance with the directions or instructions of any director of the lending company. Provisions of this section shall not apply to the making of a loan or giving of any guarantee or providing any security by a lending company if such company is a banking company or a private company not being a subsidiary of a public company, or if such company as a holding company makes the loan or gives the guarantee or provide the security to its subsidiary, and the loan is sanctioned by the board of directors of any company and approved by the general meeting and, in the balance sheet, there is a specific mention of the loan, guarantee or security, as the case may be, Sector 103(2). However, in no case the total amount of the loan shall exceed 50% of the paid-up value of the shares held by such director if his own name. In the event of any contravention of subsection 1, every person who is a party to such contravention, including in particular any person to whom a loan is made or on whose behalf a guarantee is given to or security provided, shall be punishable with the fine which extend to 5,000 taka or simple imprisonment for 6 months in lieu of fine, and shall be liable jointly and severally to the lending company for the repayment of such loan or for making good any sum which the lending company may be called up to pay under the guarantee given or security provided by the lending company. The provisions of this section shall apply to any transaction represented by a book debt which was from its inception in the nature of a loan or an advance. Director not to hold office of profit. No director or firm of which such director is a partner of private company of which such director is a director shall, without the consent of the company in general meeting, hold any office of profit under the company except that of a managing director or manager or a legal or technical advisor or a banker, Section 104. Removal of directors. A company may remove any shareholder director before the expiration of his period of office by extraordinary resolution and may by ordinary resolution appoint another person in his stead, and the person so appointed shall be subject to retirement at the same time as if he had become a director on the day on which the director in whose place he is appointed was last elected director. A director so removed shall not be reappointed a director by the board of directors, Section 106. Restrictions on power of directors. The directors of a company or of a subsidiary company of a public company shall not, except with the consent of the company concerned in general meeting, sell or dispose of the undertaking of the company, and remit any debt due by a director, Section 107. Appointment of managing director. Section 110 states that a company shall not appoint or employ any individual as its managing director for a term exceeding 5 years at a time. Any individual holding, at the commencement of this Act, the office of the managing director in a company shall, unless his term expires earlier, be deemed to have vacated his office immediately, on the expiry of 5 years from the commencement of this Act. Nothing contained in subsection 1 shall be deemed to prohibit the reemployment or the extension of the term of office of any person as managing director for a further period not exceeding 5 years on each occasion. However, no such reappointment, reemployment, or extension of term of office shall be made without the consent of the company in general meeting.